Washington. A federal appeals court on Friday reinstated key aspects former President Donald Trump's gag order that limited what he could say in a lawsuit over allegations of obstructing the transfer power. After the 2020 presidential election, a three-judge panel U.S. Court Appeals for District Columbia Circuit unanimously upheld U.S. District Judge Tanya Chutkan's ruling to extent that it barred former president from making public comments about potential witnesses in case to participate in the investigation or this criminal case. He was also barred from commenting on the case's special counsel, court staff, and attorneys and family members other than the legal staff. He may also continue to claim that the prosecution is politically motivated and that he is innocent of the 4 charges against him. We do not lightly authorize such an order, U.S. Circuit Judge Patricia Millet wrote in an opinion on behalf of the court. The panel's decision rescinds some restrictions on Trump's public comments, rescinding an appeals court's administrative stay issued in early November. Trump responded to the decision by including all of DC Truth Social posted on its platform, without specifying that it planned to appeal this decision. Trump spokesman Steve Cheung, D.C. He said the circuit panel ruled that much of Judge Chutkan's extraordinarily broad gag order was unconstitutional. President Trump will continue to fight for the First Amendment rights tens of millions Americans. Leading presidential candidate at the height of his campaign, the Biden-led witch hunt against President Trump and the American people will fail. Decision of the Court of Appeal Eduardo Munoz Alvarezpoolafp via in its decision. The D.C. Circuit said First Amendment, unquestionably provides strong protections for expression. But justices added that presence of a political campaign or speech does not alter courts' historic commitment or obligation to ensure fair administration of justice in criminal cases. The fact that a hearing participant engages in political speech cannot impair or undermine this essential judicial function, Millett wrote. By agreeing to the condition of pretrial release, Mr. Trump acknowledges that he cannot speak to witnesses in the case about political or other matters. He cannot evade this legitimate limitation by dressing up his messages to witnesses under the guise of political speech. Trump is now in the midst of his third campaign for president and is leading among Republicans vying for the party's presidential nomination. The 3 judges, Millett judges Cornelia Pillard and Bradley Garcia, said they agreed with district court that aspects of Trump's public comments pose a significant, imminent threat to the integrity of ongoing criminal prosecution, restricts the protective order. But the appeals court said the order Chutkan invoked covered more protected speech than was necessary. The justices wrote that decision was based